Good afternoon and welcome to Opinion Journal. I'm Mary Kissel. We're told that Edward Snowden has more classified leaks to come about the National Security Agency's classified anti-terror surveillance programs. Brennan Center for Justice co-director Elizabeth Goitein joins me now from Washington. Elizabeth, terrific piece in the op-ed pages of the Wall Street Journal. But
Thank you.
I'm a little confused. Do you think that this program should exist at all, or do you argue that it needs just better checks and balances?
At a minimum, if this program exists, it needs to exist in a manner that's consistent with the law and that has a certain amount of public understanding of the nature of the program. The problem here is that there is a law that governs this kind of activity, and what the government is doing right now appears to go outside of what the law allows, despite the fact that it has been signed off on by a secret court. And so the trade-offs that are supposedly being made between privacy and security are being made outside the democratic process of debate and public input.
So Elizabeth, let's talk about those checks and balances. So we know that members of Congress are briefed. We know that the FISA court is appointed. There are several judges on that court. What other checks and balances do you want on a program which is by necessity has to be partially secret to be effective?
Certain details of programs like this do need to be secret. That doesn't mean that fundamental interpretations of the law, including things like, is the government permitted to collect information first and demonstrate relevance later? Things like that do not need to be secret. The problem with the oversight that's in place now is that we have a secret court, and secret courts generally don't work very well because there's only one party that appears in front of the court. So the court is actually more likely to come to the wrong result. And if it does come to the wrong result, there's no appeal, there's no process for correcting an erroneous legal interpretation. And also for a variety of institutional reasons, oversight of classified, highly technical information by intelligence committees in Congress and other committees in Congress tends to be very limited in its effectiveness as well.
But Elizabeth, Smith versus Maryland, the Supreme Court has said it's okay to seize phone records. The federal government is allowed to seize things like our bank account details, our credit card details. They can collect our DNA at crime scenes. They're collecting metadata. Given all these other things that they can collect and given the threat out there, why does this go too far then?
The courts have held that some kinds of metadata, not necessarily all of them that are being collected, don't fall within the Fourth Amendment, that the government doesn't need a warrant and probable cause to get them under the Constitution. But then Congress stepped in and legislated some additional protections because Congress made a judgment that we valued our privacy perhaps more than the Fourth Amendment was able to protect that privacy in these kinds of instances. So when I say that these programs may have gone beyond the law, I'm not necessarily referring to the Constitution, but I am referring to the statute, which is the law of the land.
Elizabeth, I guess we've got about a minute left. I'm sorry this is so short. There's a lot to discuss here.
Sure.
How do we draw that line, though, between knowing who to target and not targeting anybody? I mean, you have to collect the metadata to know who to target. If we get rid of this program or really narrowly tailor it or give it too many political, open, public checks and balances, don't we risk losing its effectiveness altogether, or telling government, if you want to surveil people, it's going to have to be more targeted and even more intrusive?
Well, there is no public evidence that dragnet collection of information is actually an effective way to locate terrorists. What has been the standard that's been in place up until now is a very low standard, but that there needs to be some reason to believe that there's some relevance to any kind of criminal or terrorist investigation before this information is collected.
So you're supposed to know you're supposed to know who the terrorists are before you can target them? Isn't the point of this program to figure out who they are in the first place?
Not exactly. You may have a terrorist suspect and use that information to find out who the terrorist suspect is talking to. And that can help you identify people who you did not know or even suspect were terrorists in the first place. What you can't do is take Mr. Smith down the street, who you have no reason to suspect at all, and look at everyone he's talking to. I don't know how that information would help you anyway.
But we don't know that there's been a specific abuse yet. You're saying there's a potential for abuse.
Well, it depends what you mean by abuse. I mean, to me, going outside the parameters of what the law allows right there is an abuse.
But compared to the IRS, Elizabeth, that's a real abuse. I mean, if Mr. Snowden had really the smoking gun, don't you think he would have released it?
I believe that he did release something that to me is a bit of the smoking gun. I think if the government violated the law and is doing dragnet surveillance of every single American's telephone records, that's a pretty big deal.
Okay.
And I don't.
Well, it's a complicated topic. There are many different sides, and I am so grateful that you've come on the show today. Brennan Center for Justice co-director Elizabeth Goitein. Read her op-ed. It was in the pages of the Wall Street Journal, and it's up on WSJ.com. Elizabeth, thank you so much for being on the show.
Thanks very much.